Barb. May I help you?
Good morning, Barb. My name is Amy Weber, and I understand that you can give me information regarding my case with Dr. Timothy Kinsella.
Okay, I can tell you the status of it if that's what you need. By information about your case.
My attorney notified me yesterday that the board has closed the case.
Okay.
I'm stunned. I'm devastated. I submitted to the board a record of my telephone calls. He called me 14 times, soliciting me for a sexual relationship. My husband sat, 8 inches away and listened to one of the conversations. He testified that to the board. I gave the board emails that I sent to Dr. Kinsella regarding the telephone calls. Dr. Kinsella stuck his hands up under my clothing when I refused to undress in front of him. At one time, he asked the intern to leave the room when he did it. Another time, he did it in front of an intern. I submitted to the board all of the stuff that's saying that he did these intimate examinations. I mean, he wrote in his summary report that he did these intimate examinations, yet I was clothed. I do not understand how they did not take action.
Well, let me take a step backwards first, okay? When you're saying they did not take action, the board has a variety of different things that they can do. Public action is one form, but that's not the only form of action that the board can take. There are a number of other things that the board can require physicians to do that are not made into public records. So I'm not saying to you that in this case that there wasn't anything at all done. There was not a public finding, so there was not anything officially put out into the public records. But that doesn't mean that the board didn't do other things internally that would address the issues that you raised.
How is that any solace to the victim?
Well, I can't answer that. All I can tell you is, as far as what the board's range of authority is, it has a wide range of authority as far as what they are able to do to make sure that physicians comply with the law.
Well, he just, he moved on to New York. He's now the director of the Stony Brook Cancer Center in New York. So he walked away scot-free.
Well,
I cannot tell you how devastated I am.
I'm not sure what more I can tell you. I mean, I can't tell you the specific steps that the board took. I'm not permitted by law to be able to tell you that. I can talk to you generally about what the process is. I can talk to you about how review happens. One of the people that reviews the complaints is in fact a physician. The other person is a consumer member of our board, so there are 2 individuals who look at all of the results of the investigation, and they make a determination about what should be the next steps in handling any case that comes through the board. And that was done in your case as well. So that's it's within the board's purview to decide whether or not they're going to issue some sort of a formal public charge. But again, they have a number of tools that don't go into the formal public realm. And that those are all available in each case that the board reviews.
So, and you're saying that if I came up to the board, there's no way I could even see any of that information?
No. We have a statutory obligation that we're not even permitted to put that out there. That's state law. That's not a choice of any one individual here. That is state law that we are not permitted to share that information.
Can you tell me then, this is what I don't understand, is, I kept record of all of the calls that I made. On January 15th, Krista told me that it was an extensive review and that that's something good because it means, it's a good sign to you because it means there's something there. On March 20th, I was told it was assigned to an enforcement staff. Again, that means that's something good for you. On May 8th, Krista told me it's an extensive review. She said it's going to a different process. And she said if your case was going to be closed, it would have been closed already and a letter would have been sent to you because the investigations closed at the end of, or in January of 2008. And it was moving forward from there. On June 2nd, Sue Bigham told me it is very open and very active, and UH is doing everything to make sure that you don't sue them. On October 15th, Krista told me, your case is open and active. They had him in the office. They worked with him. It's open. Yes, it's active. And again, she said that it means that something, when it goes on that this long, generally it means that something's going to be done.
And I'm not denying any of that. What I'm saying to you is, within that realm of what the board has the authority to do, when it comes to a decision point where we can do things that are internal, that are the types of things that they were explaining to you as the complaint was open and was moving through the process here. Those are all internal decision points for the board. Those don't go into the public realm. If the two board members who oversee our investigations believe that the internal processes that have been put in place so far in dealing with that position were sufficient, then they do not move on to a formal public charge. So,
do you know?
There's nothing that's inappropriate or wrong about what you were told and what you've just relayed to me. That's all true. That's what was going on internally, but that doesn't guarantee in any way that that's going to turn into a formal public charge.
You know, they continually commit these acts, and to me, it feels as though he has just been excused again. Because if there's nothing publicly done, if his employer, you know, in the state of New York doesn't know, if the medical board in Ohio or in New York doesn't know, then it's meaningless.
Well, again, let me back up a little bit here. We have some statutory authority that if the New York Medical Board made a request for information, we do have statutory authority to share certain information with a sister board. So New York need only make a request, and then our board would review that and release to the New York board what we felt was appropriate to release to them. So, you know, I don't know that the New York board has made such a request. I don't know whether they have or have not. I'm not involved in that end of the process. But from a legal perspective, the New York board can make a request for that information, and then they can make their determination as to what they want to do. We have that statutory authority to share information with the sister board. So if they made the request and they received the information, you know,
and they thought it was okay.
It's their determination whether or not they're going to grant the license. I'm not saying that they thought it was okay. I don't know what they did in New York either. I mean, I'm just telling you that there is a statutory authority there for us to be able to share information with a sister board.
Yeah, well, I mean, he did get his license.
That's up to the New York board whether or not they're going to grant that license.
So, if I come to the board, is there any information at all that I can see?
The only thing that we would be able to share with you would be your original complaint, the information that you have mailed in to us. So I know you've mailed in a number of letters and faxes, and then a copy of the letter that we've already sent you closing the complaint.
I didn't get that yet. When was that mailed?
It should have been mailed. The complaint was closed on the 9th of December, so the letter would have probably been mailed 10th or 11th, somewhere right around in there. You should have received it by now.
No, I haven't.
It probably was sent to your attorney. I'm sorry.
Yes.
The complaint was filed on behalf of you by your attorney, so it would have been sent to Wade Sanders.
All right.